Good morning. Aloha and welcome to the statewide training on fair housing for 2023. Our theme this year is Fair Housing, Choices for All Voices, Building an Equitable Future. And today is our third session titled Disability, Reasonable Accommodations, Reasonable Modifications, and Assistance Animals, moderated by the Legal Aid Society of Hawaii. My name is Daryl Young, and I'm the Fair Housing Coordinator for the Department of Community Services. On behalf of Mayor Rick Blangiardi and the City and County of Honolulu, it is our pleasure to host Fair Housing Month for the state of Hawaii. Again, on behalf of our statewide Fair Housing Coordinators Group, we thank you for taking the time to join us with this very important training. We hope you enjoyed last week's Ask the Expert session with Representative Troy Hashimoto from the Hawaii State House of Representatives, Ms. Yi Yang Yaya Wu, a fair housing attorney with Roman Colfax PLLC, and Ms. Jennifer Stoltz with the U.S. Department of Housing and Urban Development, Honolulu's Fair Housing and Equal Opportunity Office. And today's session will cover the topics of disability, reasonable accommodation, reasonable modifications, and assistance animals. This is one of the more popular sessions each year. I would like to take this opportunity to go over a few things to know before we start. First, when you signed in, you should have found a link to the most up-to-date PowerPoint presentation being shown today. If not, I believe Dylan put a link in the chat box where you could go. Second, because of the size of the conference, all attendees' microphones and webcams have been disabled. We've collected a lot of questions from registrants on various topics over the past few weeks and when you applied. However, if during the training session you would like to ask a question of the presenters or panelists, we ask that you direct your questions to the all panelists segment in the chat function of the WebEx program. We have people monitoring the chat room and will be gathering your questions as they arrive and forwarding to the presenters and panelists. Presenters and panelists will try to get to as many questions as they can during the Q&A portions of this training, time permitting. Please take a second to find that feature now. Finally, I'd like to reintroduce the Fair Housing Coordinators Group that participated in the planning and coordinating of this conference and ask them to turn their cameras on when introduced. From the County of Kauai, Jocelyn Marie and Steve Franco. For the City and County Department of Community Services and the Office of Housing, there is myself, Daryl Young, Emma Grohovsky, and Dylan Ramos, Brian Minatoya, Terry Kanashiro, Allison Mikuni, Ailina Laborte, and Cheryl Belisario. From the County of Maui, we have Linda Munsell, Buddy Almeida, and Saumalu Mataafa. From the County of Hawaii, Christina Pineda and Ann Bailey. From the State of Hawaii Department of Human Services, Homeless Programs Office, Harold Burking III and Anna Marie Piloton. From the State of Hawaii Housing Finance and Development Corporation, Christopher Woodard, Terry Higa, and Lance Dong. From the State Department of Hawaiian Homelands, Cynthia Resentes. From the State of Hawaii Public Housing Authority, Joaquin Manabusan and Ryan Akamine. From the Legal Aid Society of Hawaii, Cynthia Moore, Nicholas Severson, William Tu, and Pua Marquez. From the Hawaii Civil Rights Commission, Marcus Kawatachi, Carolyn Vieira, and Heather McVeigh. From the U.S. Department of Housing and Urban Development, Jelani Madaraka, Jennifer Stoles, Pamela Zai, and Shelby Kolek. I would now like to reintroduce you to Christina Pineda of Hawaii Island and Nicholas Severson and Cynthia Moore, who will be your moderators for today's session.
Thank you, Daryl. Thanks for hosting today. I'll go ahead and share and let Legal Aid get started.
Thanks, Christina, and thanks, Daryl, and thank you everyone for being here today. As Daryl mentioned in the intro, today we're going to be covering disabilities and disability discrimination, and we're going to do that with a particular focus on reasonable accommodations and modifications. Next slide, please. So my name is Nick Severson. I am the managing attorney of the Housing and Consumer Unit at the Legal Aid Society of Hawaii. Previous to that role, I was a staff attorney in the units, and prior to that, I was a staff attorney in our Maui office. Nice to see some familiar names from the Maui community here, so thank you in particular for being here. I think my colleague Will is still having some technical difficulties here, so I'm going to toss it over to Cynthia.
Hi, everyone. Good morning. Hope you're all doing well. My name is Cynthia Moore. I am an attorney with the Housing and Consumer Unit. I've been with the Legal Aid Society of Hawaii since 2019 and been in the Housing and Consumer Unit since, I think it's been 2 years already. And I am happy to be talking to you today about reasonable accommodations and modifications and assistance animals.
So just a little background on the organization. So the Legal Aid Society of Hawaii is the state's oldest and largest nonprofit law firm. So we handle a variety of legal issues, but we do have a specific housing and consumer unit. We are a fair housing initiatives program, meaning we receive federal funding from the U.S. Department of Housing and Urban Development, which allows us to advocate for victims of housing discrimination. And it also allows us to provide technical assistance, which allows us to provide additional legal information to those that seek it. Next slide.
So I'll go over the agenda for today. So first we're going to start out by talking about disability in general and how it fits in under fair housing law. And then we'll get into a little bit more specifics on reasonable accommodations and modification requests. We'll take some of your questions, which you can pose either in the chat to everyone or all panelists, or you can put it in the Q&A. And then we'll take a quick break. And after the break, we'll go over assistance animals, and we'll get into some examples of, reasonable accommodations and modifications. And then before we end, we'll take more of your questions, and we'll end promptly at noon. Next slide. All right. So just a quick disclaimer. So the information presented today in our training is intended to provide only legal information and not legal advice. So legal information is generic, doesn't address any particular cause of action, whereas legal advice applies, specific law to certain set of facts. So we can't recommend certain courses of action. If you have questions, just make sure to keep them general and know that we can't provide you any legal advice for today. So just to go over some basics as to why we do this presentation pretty frequently. I know we did a presentation on reasonable accommodation modification requests last year, but as you're well aware, people with disabilities are prevalent in both the United States and in Hawaii. 26% of people in the US have some type of disability, so it's 1 in 4, which is approximately 61 million adults. The types of disabilities vary. So as you can see, about 11% suffer from some disability that's involving cognition. 13.7% have mobility problems. 5.9% have hearing impairment. 6.8% have independent living concerns. 4.6% have vision impairment, and 3.7% have trouble with self-care. Next slide. So as you can see, in the state of Hawaii, it tracks very similar to nationwide. 1 in 5 persons in the state of Hawaii have some type of disability. And as you can see, it again varies. So disability is a large portion of what we see in our work in housing discrimination. So 60% 0.9% of complaints that were filed with HUD involved disability. 32.5% of complaints were based on disability with the Hawaii Civil Rights Commission, and 43% were failure to permit a reasonable accommodation, and 75% were based on discriminatory terms, conditions, privileges, or other services and facilities.
Thanks, Cynthia. So with that context in mind, kind of understanding the volume of folks that are experiencing disabilities and understanding that they're going to have a variety of unique needs in order to have equal access and enjoyment of their housing. We're going to take a step back here and talk a little bit about the definition of disability under the Fair Housing Act. So, disability can be defined different ways in different contexts, but for the purposes of the Fair Housing Act, it's defined very specifically and it's very broad. So it's considered a disability is considered a physical or mental impairment that substantially limits one or more major life activity. So what's a major life activity? It can be a variety of things. So it can be walking, seeing, hearing, speaking, breathing, etc. So with that broad definition in mind, it's important to be mindful of the different ways in which someone's physical or mental impairment may impact their life and their major life activities. So just be mindful of the different ways that disability can be, can impact one's life. Next slide, please. All right, so I'm just going to take a brief pause here because I'm seeing in the chat that some people are having issues hearing me. I don't know if that's on their end or on mine. Are folks able to hear me okay? Generally? Okay. Seeing at least a handful of yeses, I'm going to assume that audio issues are on most other folks' end. My apologies for the folks that can't hear. So moving on then. So an impairment can be either physical or mental, and again, it just needs to substantially limit one or more major life activity. It can be a recorded impairment, so that is something that you may think of as something that someone has a diagnosis of, right? So, a diagnosis of anxiety or depression or, any number of things. It can also be someone being regarded as having such an impairment, meaning they may or may not actually have a diagnosed disability, a recorded disability, but they may be perceived as having such. So this can manifest in a variety of ways as well, but one place that we see this kind of frequently is maybe with folks that are houseless, being perceived by housing providers as having some type of mental health issue or disability and being discriminated against on that basis. Even if an individual does not, in fact, actually have a diagnosis of that disability, if they're being discriminated on the basis of being regarded as having that disability, it can still be considered disability discrimination under the Fair Housing Act and state fair housing law. Next slide. So just a few kind of examples to illustrate, how varied disability can be, right? So I think using our middle example here, Benny has limited mobility. This is a pretty easy issue for folks to understand and for folks to see. So, obviously a disability can be something that is apparent and obvious. A person may be able to know immediately that a person has a disability based on how it's presented. But you may also have individuals with disabilities that are not readily apparent, right? That you may not know unless, the individual shares that information with you or otherwise, makes a reasonable accommodation request or things of that nature. So we have the example of Arthur here who has anxiety. Anxiety can be considered a disability under the Fair Housing Act as it could substantially limit one or more major life activities. And again, Clarice on the right side here with diabetes, same thing. So again, it may not be apparent that Clarice has a disability, but you can imagine, the different ways in which Clarice's disability, diabetes may impact one or more major life activities. Next slide. So one thing we get a lot that folks I think are generally curious about is the idea of drug addiction or alcoholism. Can alcohol abuse disorder or substance abuse disorder be considered disabilities under the Fair Housing Act? The short answer to that is yes. So Congress and the courts have found that the term physical or mental impairment can include drug addiction and alcoholism. So again, if there's only a few things that you take away from this presentation, I would just encourage you to remember that the definition of disability under the Fair Housing Act is rather broad. It's important to be mindful of that and to be thoughtful as folks come to you with reasonable accommodation requests or reasonable modification requests. Next slide. So when we're thinking about how this process plays out, what is a reasonable accommodation request, right? This is sort of the backbone of this presentation and in the way that housing providers are most frequently going to encounter folks with disabilities, right? They're going to be making reasonable accommodation requests, which is going to be asking for some change to rules or policies or practices in order for them to have equal use and enjoyment of their housing. So it's not necessarily that you're treating everyone equally, but it's that you're treating everyone fairly, right? What gives someone the same use and enjoyment of their property may be different from person to person, dependent on their unique disability-related needs. So this path here just kind of illustrates the process that we're going to talk about a little bit today. So you'll have a request that's made. You can see at the bottom of the screen there, an individual making a request to a housing provider. Depending on the nature of the disability and whether or not the disability is apparent, there may be what's called a verification of need involved, and we'll talk about that a little bit in future slides. And then depending on whether or not that need is met, it can be granted by the reasonable accommodation request. The housing provider may be required to engage in the interactive process with the individual that made the request. And again, we'll talk a little bit about that more later. And then our very top graphic there, we've reached some type of resolution here. It's important to work towards, meeting the person's disability-related needs. So the interactive process is essential to try to understand what those needs are and make sure that housing providers are doing what they can to ensure that individuals with disabilities are able to have the same use and enjoyment of their property as folks without disabilities. Next slide. So just to give you a few examples of reasonable accommodations and what they may look like. So again, just to reiterate a point I made earlier, it is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a disabled person to have an equal opportunity to use and enjoy a dwelling. So again, this is a change to sort of a standard policy or standard practice that a housing provider may have in an effort to make sure that the individual with a disability has their needs met. So our first graphic there is someone who has a visual impairment having a seeing eye dog, for example. So that's a very kind of classic and straightforward example. Someone who needs the assistance of that animal to navigate the space around them, right? So that's a reasonable accommodation, right? So even if there's a no pet policy, for example, as we'll talk later, assistance animals are not pets. This person would be entitled to have this animal to provide this service for them. The second example we have is a little more abstract in terms of the graphic, but what we're getting at there is the idea of time. It may be that a person with a disability needs more time to vacate when they're given a notice. It may be that they need more time to pay the rent, given some circumstances related to their disability. It would be entirely appropriate for an individual with a disability to make a request for more time if that's something that would meet their disability-related needs. And then lastly, we have a little parking graphic there. This is also sort of a classic example, right? So somebody with a mobility impairment needing a parking spot that is closer to their unit, perhaps. So seeking an assigned spot near their door, for example, rather than unassigned parking or otherwise assigned spot that is further away from their unit, right? Just to make it easier for them to travel from their unit to their vehicle. Next slide. So a related concept and something that you'll sometimes see as well is the idea of a reasonable modification. So the way that the request is made is similar, but it's a slightly different change that's being requested, right? So this is actually a structural change made to the premises, again, to provide the individual with the disability to have full enjoyment of the premises. So This might be, referencing the first graphic here, this may be grab bars in a shower, for example, or removing a bathtub and putting in a walk-in shower or a roll-in shower, so someone has an easier time navigating the shower situation. Middle example, and this is another kind of quintessential example, right, is a wheelchair ramp. So maybe there's stairs to the front of the unit. A person that uses a wheelchair may need a ramp rather than those stairs so they can have access to their unit. And then our last example there, someone with a visual impairment, someone with a hearing impairment may not be able to hear the standard smoke alarms that would go off in the event of a fire. Another reasonable modification example could be installing a light feature that would provide them with the same type of alert that there was a safety issue, right? So instead of the audio alert, they would have this visual indication that there was some need to leave the unit. So those are just some examples of reasonable modifications. Next slide. So the question that always comes up, and I'm sure it has maybe already come up in the chat here, so who typically pays for modifications? And I am a lawyer, so I'm required to say it depends. But generally speaking, it's going to depend on who the housing provider is, right? So if the housing provider receives a federal subsidy or is federally funded in some way, the housing provider is likely going to be the party that needs to bear the cost of the reasonable modification. If it's just a private housing provider and there's no federal funding or federal subsidy, then the individual making the request, so the individual with the disability, would be the one that would be required to actually bear the cost of making the changes to the property. Next slide. So now we're going to talk a little bit about what this process actually looks like, because I think sometimes this is where housing providers can run into trouble, right? Not understanding exactly how this process should be playing out. So the first concept that I want to talk about here is the actual making of the request, right? So the individual making the requests, it can be made at any time by anyone in any manner. So it can be made orally, it can be made in writing, right? It can be a handwritten note, it can be an email, it can be a really formal letter, it can be made on a housing provider standard form. All of those ways of making a request are entirely acceptable. It can also be made at any time, right? So it's not like there's a window of time, prior to move-in or after move-in that someone can make a request. A reasonable accommodation request or reasonable modification request is appropriate at any time, and the housing provider should engage with the individual making that request and take that seriously, regardless of the timing of that request. And then lastly, it can be made by anyone. So this can be the individual with the disability, right? So the individual that actually has the need and has the desire to have an accommodation or a modification made. It can also be a family member, a friend, a healthcare provider, a social worker, a case manager, really anyone on their behalf, and that would be entirely appropriate. So it's important to, again, if I can encourage one takeaway, is just sort of think broadly about these things, and especially in terms of making a request, it can happen in any number of ways. Next slide. So a verification of need is something that may be requested by the housing provider in certain situations. So a provider is entitled to obtain information that is necessary to evaluate if a requested accommodation may be necessary because of a disability. This should only be requested, however, if the disability-related need is not apparent, right? So going back to the example I talked about earlier, the individual with the visual impairment that needed the assistance of a seeing eye dog, there's no verification of need required in a case like that, right? The disability is apparent, the disability-related need is apparent. It would be inappropriate for the housing provider to seek a verification of need in a case like that, because it just ends up being cumbersome and places an additional burden on the individual with the disability. However, there are plenty of circumstances, and some that we'll go into in more detail during the presentation today, where requesting a verification of need may be appropriate. So we'll talk a little bit more about the concept of emotional support animals a bit later, but this is one that is kind of a clear example of when a verification of need would be appropriate, right? So it would be unclear to the housing provider why an emotional support animal may be needed, and what that emotional support animal, why they may meet that individual's disability related need. So in cases like that, and in many other cases where the disability related need is not apparent, it would be appropriate for a housing provider to seek this verification of need from the individual that is making the request. Next slide. So that sort of begs the question, right, of who can provide this verification of need, right? So the term that's important to remember here is it can be provided by any knowledgeable provider who is a reliable third party who is knowledgeable about the person and the disability. So, you know, the most common examples of this are typically healthcare providers, right? Doctors, therapists, counselors, things of that nature. But it can also be someone at a case management organization. It can be, you know, someone at a Alcoholics Anonymous support group. It can be a social worker. It can be any number of individuals, right? So again, think broadly about it, but as long as the individual is a knowledgeable provider and meets this sort of definition of a reliable third party who has knowledge, they would be an appropriate person to provide the verification of need on behalf of the individual making the request. Next slide. So what does the verification of need actually need to do, right? So if the housing provider wants this additional information, they ask for a verification of need. What does it need to contain, right? So what boxes need to be checked off in order to grant the request, right? So it really needs to have three main components. So the first, explaining that the individual meets the Act's definition of handicap or disability, right? So again, would need to indicate that the person has an impairment that substantially limits one or more major life activity. It also needs to describe the needed accommodation, right? So this individual needs an emotional support animal. This individual needs additional time to do XYZ, whatever the case may be, right? And then finally, it needs to show the relationship between the disability and the need for the requested accommodation. So this is kind of commonly referred to as, you know, demonstrating the nexus, right? So connecting the dots for the housing provider, how this request meets the individual's disability related need. And assuming the verification of need checks off these boxes, that should really be the end of the inquiry for the housing provider. At that point, it should be something that they are granting. Next slide. So on the flip side of that, what shouldn't the verification of need have? Like what cannot be requested by a housing provider? So information regarding the nature and the severity of the disability would be inappropriate, right? There's nothing that the housing provider would need in terms of specific diagnoses or duration or things of that nature that would be inappropriate, that would not be helpful in evaluating whether or not the request would be should be granted or not. They cannot request medical records, so you know any type of trying to get at anything that's more sensitive, right? So nature and severity, medical records, medical history, all of that is out of bounds for housing providers. And then finally, and this goes back to sort of the initial point in terms of making the request, housing providers can't require their own forms, right? So if an individual makes a request orally, or if they send an email to the housing provider, or write their own handwritten note, that's sufficient. They've made the request. The housing provider can't then turn around and say, okay, also you need to fill out this form. We'll talk about this a little bit later in a different context, but in the event that the housing provider, for their own documentation and own records, wants to keep some type of form on their end, that's fine. But they can also, note that information on their own end, right? So if an individual comes into their office and makes an oral reasonable accommodation request, the housing provider can just, write down on such and such a date, this individual came to my office, they made this request, etc. And that can be included in the client's file, which would be entirely appropriate. But you can't be making the individual making the request actually conform to whatever form it is that you may have as standard. With that being said, you can still have a form and you can still provide it to folks. It may make it easier for some individuals to make that request. You just can't require it. Next slide. So the hope is obviously that reasonable accommodation requests generally will be granted, but there are certain circumstances in which it would be appropriate for a housing provider to deny a reasonable accommodation request. One such example would be if there's a fundamental alteration to the provider's operations. So for example, just to kind of illustrate this, if there is an individual who maybe has mobility related issues, and they ask the housing provider to carry the groceries up and down the stairs for them as a reasonable accommodation. The housing provider isn't in the business of carrying groceries up and down stairs for tenants. It's just not the nature of what they do. So because it's not part of what they do as a housing provider and it would fundamentally alter their operations, that would be a reasonable accommodation request that a housing provider could deny. The second is an undue administrative and financial burden. And this is a little nebulous to talk about because it's going to depend on the housing provider, the size of the housing provider, the cost of the request. Most reasonable accommodation requests don't have a cost associated with them, right? So allowing an individual to have an emotional support animal doesn't cost the housing provider anything, for example. But there are some instances in where the request may cost some sum of money, and it'll really just depend on the housing provider and what the nature of the request is and whether or not it would actually create an undue or administrative burden. And then lastly, direct threat. This typically ends up being seen in the context of assistance animals. So if there's a determination that the individual or animal poses a direct threat on an individual assessment that's based on reliable objective evidence, and that's the key part, reliable objective evidence, then it could be denied. So you can't deny an emotional support animal, for example, because it's a pit bull and you think that pit bulls are particularly dangerous. That's not reliable or objective, right? If the animal has a history of injuring others on the property, then that's a different thing, right? Now there's reliable objective evidence. It may be appropriate, to do something with regards to that specific animal. So we'll talk more about that. I don't want to get too into the weeds on that specifically at this point. I know Cynthia will cover that in a bit, but those are just kind of some general frameworks for thinking about the appropriate circumstances for a denial. Next slide. All right, so I mentioned this earlier. I just want to talk a little bit more about the interactive process and what that means. So an individual makes a request, the housing provider seeks the verification of need, and now they are kind of at a point where, okay, I have more information, but I'm not exactly sure if I can grant this request. Maybe there's some additional information that's missing. Maybe there's something that needs to be made more clear. What's the housing provider supposed to do at that point? The answer is to continue to engage with the tenant or the person making the request, right? So the ultimate goal is to meet the individual's disability-related needs. So if something is unclear or if a request can't be granted for some reason, the housing provider should be engaging directly with the individual making the request in an effort to gather additional information or communicate about what should or shouldn't happen in order to try to get an accommodation granted, right? So it shouldn't just end at, hey, this verification of need was kind of unclear, so I'm going to deny it. The housing provider really should be going back to the tenant, engaging with them and seeing if they can provide what would be needed to actually grant the request. And I just want to reemphasize, it's really important that this process be done directly with the person making the request, okay? So they're the person making the request, they're entitled to engage in that process. So shouldn't be something that's done with the doctor or the knowledgeable provider or anything like that directly. That's something that the person making the request would be better equipped to do. Next slide. All right, so just a little callback from last year. For those of you that were with us for the expert panel last year, Paul Smith, who worked for HUD for many, many years, had sort of a nice mnemonic to help you kind of think through how to analyze these types of cases. So if you want to check out a more thorough conversation of this, Paul did a better job than I'm sure to do in outlining this example. It was the week 4 presentation from last year, which I believe should be available at the city and county's website. But the acronym here is DANCE, right? So the analysis goes as follows. So the complainant is disabled, all right? Then we move on to there's a request or notice of a need for accommodation that is denied, right? So this is where we're starting to figure out if the housing provider has denied a request inappropriately, right? there's a nexus between the request and the complainant's equal opportunity to use and enjoy the dwelling due to their disability, right? Does the housing provider have any of the defenses, right? So is there a financial or administrative cost or burden that is not undue? And then the request does not establish a fundamental alteration. So this is kind of a framework for thinking through, and it looks like Dylan actually just linked it in the chat. Thank you for doing that, Dylan, for some further discussion on sort of this analysis. But this is the type of analysis that HUD or HCRC is going to use when they're looking at these type of complaints to understand whether or not disability discrimination occurred. So just something to keep in mind and just be mindful of as you are evaluating reasonable accommodation or reasonable modification request. Next slide. All right, so I know that was a lot of information relatively quickly. So we wanted to take a few minutes to answer some questions here. Brian?
Hi, good morning, everybody. My name is Brian, and thank you so much, Nick, Cynthia, and William, for your presentations today. I look forward to our second part of session soon. But questions and answers is what we're going to do now. We have a couple questions that we're going to go over, and I'm excited to hear about your responses or reactions. So your first question is depression a disability?
Yes, so depression would meet the definition of disability, right? So it's a physical or mental impairment. Obviously, depression would be a mental impairment that would substantially limit one or more major life activities, right? So it may impact someone's ability to sleep, it may impact their ability to process information, it may impact their ability to do a variety of things, right? So yes, depression would certainly meet the definition of disability.
Okay, that's good clarification there. I don't think. Let's see what we got here. Oh, okay. Sorry, I had the wrong window up. My bad. So for reasonable accommodations, any documentation process for the reasonable accommodation cannot list the nature of one's disability. Is that correct? So it's like a yes or no question.
So the housing provider shouldn't be seeking that information. Sometimes someone that is providing the verification need may indicate something like that on the verification. That'll happen from time to time, but the housing provider should not be requesting that information.
Okay. I think we have a couple more questions here. I know our team is doing a good job of collecting that information. So please submit your questions to the chat box or the Q&A function to the WebEx. I have another question here. This question asks, what is considered reasonable accommodation in terms of dollar amount? I guess, is there a dollar figure in terms of considering a reasonable accommodation request?
I don't know if you want me to take this one.
Okay, I can take this one. Unless you want it, Cynthia, go for it.
No, you go for it. We can add things if need.
Yeah. So like I mentioned when I was talking about this a little bit earlier, it depends, right? So most reasonable accommodation requests are not going to come with a cost to the housing provider. In the event that they do, it would really be sort of on a case-by-case basis to determine whether or not it was an undue financial burden on the housing provider, right? What may be an undue financial burden on a small mom and pop landlord may not be a undue financial burden on, some large property management company that has, 1,000 units across Oahu or something like that, right? And then in terms of reasonable modifications, to the extent that sometimes folks I know conflate those terms, again, reasonable modifications, so these are the actual structural changes that would almost certainly come with a cost. If it is, if it's federally funded or federally subsidized, then the housing provider is likely going to have to bear the cost of that. If it is not, then the individual making the request would be responsible for paying for that.
Okay, thank you, Nick, for the response for that question. But I value everyone's input too, so it's really good. These questions can be very loaded sometimes. When I'm reading it out, it sounds easy, but when you're interpreting it, it makes me understand the question more. This next question I have here is for handicap parking stalls on property, can we reserve them to a specific resident with a placard?
I can take this one if you want, Nick. So if the person requests an accommodation for a particular handicap parking spot, yes, the housing provider can grant that accommodation, as long as it's not, like Nick said, undue financial burden or something like that. Usually that type of thing would not be burdensome to grant.
Okay, I think we have time for one more question before we should stay on track for the presentation schedule. Let me see here. Does the tenant need to resubmit a verification of disability letter if they re-enter housing? So this might be asking how often a tenant needs to submit a verification, or if they have to do it if they re-enter a property, or like how often, like when should they provide this verification?
Yeah, so as I'm understanding the question, and maybe Cynthia, you can jump in here too if I'm maybe missing it. So if an individual is remaining in the same property, or even renting from the same landlord or same property management company, they should not be made to continually make requests, right? If they've made the request and it's granted, that's really it, right? It should continue to be granted. And they should continue to have that accommodation made regardless of, how long they're at the property or whatever. Obviously if someone is moving to a new unit, a new property manager, whatever, and they're not familiar with it, right? They've not worked with this person before, they haven't encountered this person before. Just because an accommodation was granted at the last place, they would certainly have to make a reasonable accommodation request at the new property, right? So if a person is moving or changing housing, then yes, they would have to make the request again.
All righty, thank you so much. I think we're good on this portion of this presentation, but let me see if we have any other questions here that I didn't go over. Oh, sorry about that. It's kind of hard to go bounce from screen to screen. I went in WebEx screen into my screen. Alrighty, so is obesity a disability? If the landlord cannot provide a larger toilet, seat, or toilet bowl apparatus, who can they turn to?
Short answer is yes. If the question is whether obesity may substantially limit one or more major life activities, it certainly can, right? And it sounds like the question is being asked of modifications. So generally, as Nick said, the cost of the modification, for example, for a larger toilet seat apparatus, would fall on the individual unless there's certain types of federal funding involved, in which it may fall on the housing provider. But generally for modifications, unless there's that, federal funding involved, the cost wouldn't be on the housing provider.
Okay, thank you, Cynthia. Very good. I think we have time for 2 more questions then. I know I said earlier my time is kind of off, so I apologize about that. You guys are masters of this presentation. Let's see here. Is having a heart, stent, or having a heart condition a reasonable request to move to a lower floor? Is that considered a disability?
Yeah, so one can imagine how having a heart condition may impact, the major life activity of walking or breathing, right? You can see how having maybe some medical challenges related to that could certainly meet the definition of disability, and it's also easy to imagine the nexus there, right? So walking upstairs, for example, may exacerbate those heart-related issues, so a lower floor unit may be appropriate for an individual with that issue, because then they don't have to go up the stairs and have that exacerbated.
I think we have enough time for another question. We have here, for private residential with no federal assistance, can the resident be required to pay to reverse the accommodation when they vacate? I'm assuming this could be a reasonable modification, so they modify the unit or some type of change to the unit. So the question to ask again, for private residential with no federal assistance, can the resident be required to pay to reverse the accommodation when they vacate?
Yes, they can. So the housing provider would grant the request, that the individual would pay for making whatever modification, but then yes, the landlord could require that they undo whatever that modification was, right, once they vacate.
Okay, I think that just wraps it up. So I'm going to pass the baton over to the awesome team of Legal Aid to continue their presentation.
All right, so I think at this point we'll actually take a short break so we can get everybody stretching and coming back for a good second half here with some more talk on assistance animals and then a few sort of case study examples. So I think we'll come back, what do we think, about 10:55, Cynthia? Does that sound all right? All right, so just under 10 minutes. We'll be back on at 10:55. Thanks, everybody.
So I finally settled and said, okay, fine. I'm okay now. So I went to Daryl this week.
Hopefully we're good to go here. I will toss it back over to Cynthia Moore to keep on with assistance animals.
All right. Hi, everybody. I hope you were able to get some water, stretch your legs, because we're about to get into assistance animals now, which I know is the hot topic of this presentation every year. So let's get started. Next slide, please. All right, so just as a general intro, what are assistance animals? Assistance animals is kind of a broad word for both, that encompasses both service animals and support animals. So assistance animals are animals that do work, perform tasks, assist or provide therapeutic emotional support for individuals with disabilities. I know that Pamela Zai touched on this during her presentation week one. We'll go over it again. So service dogs are any dogs that are trained individually to do work or perform a task for the benefit of an individual. So someone with a disability has an assistance, a service dog. They may have, for example, a seeing eye dog that would be qualifying as a service dog. The dog just needs to be trained to do work or perform a task for that individual's disability. Support animals are different. So support animals provide therapeutic emotional support that would alleviate one or more disability-related symptoms. So for example, if someone has depression and they need therapeutic support for their depression, they may have an emotional support animal that assists them with their disability. Next slide. All right, so let's get into service dogs and reasonable accommodation requests. So if the person's disability is readily apparent, again, a common example of, readily apparent disability may be a person with visual impairments who may have a seeing eye dog, then, there is no need for a verification of need. No further inquiries should be requested from the housing provider. It's not appropriate for them to ask further questions because it's clear that it is a service animal. So if the individual's disability is readily apparent, they shouldn't be asking any further questions or requesting verification of need. Next slide. All right, so if the person has a service dog and the disability is not readily apparent, the housing provider can ask two questions. So they can ask, is the animal required because of a disability? And what work or task has the animal been trained to perform? If those two questions are answered in the affirmative, yes, the animal is required because of a disability and it's trained to do X task. No verification of need is required. No further inquiries should be asked by the housing provider because it's clear that it is, again, a service animal. Next slide. So we'll get into emotional support animals now. So as I talked about before, emotional support animals can be any animal that is there to support a person's disability related symptoms. So as you can see in the graphic, we have a variety of different animals in the state of Hawaii. Obviously, you can't have an emotional support snake, for example, because snakes aren't allowed in the state. But it can be any type of animal that is domestic or domesticated. And if a person is requesting their emotional support animal, for example, be in the unit in a place that has a no pets policy, for example, as I talked about before, emotional support animals or assistance animals are not pets. They may need to request an accommodation. And if their disability is not observable or not apparent, then the housing provider can then, again, request a verification of need from the person to demonstrate that there is some sort of nexus between the request and the person's disability-related needs. And the relationship or connection needs to be demonstrated by that verification of need, right? Okay, next slide, please. So we're going to talk a little bit about reasonable restrictions. So a housing provider, if a person has an assistance animal, a housing provider can put reasonable restrictions on emotional support or service animals. So they can require that they be licensed with the county, for example, if that's something that's required. They can request that the animal be vaccinated with documentation of vaccination. They can ask that the animal be registered with the housing provider. So, they have it on file that this person has this animal in their unit. The animal needs to, they can, request that it meet minimum sanitary standards, and that the person with the assistance animal pick up the animal solid waste. And it needs to be under the control of its handler. So generally, the housing provider can set those reasonable restrictions on the individual if they have an assistance animal. So now we're going to talk about some examples of assistance animal discrimination that we see. So one example is undue delay. So if the person requests the accommodation for the assistance animal and the housing provider just doesn't get back to them, or keeps delaying on whether they're going to grant or deny the accommodation request, that would be potentially an example of discrimination under the Fair Housing Act. Another one, I think I saw a few questions related to it in the chat, are setting breed restrictions. So no animal is inherently dangerous, no breed of animal is inherently dangerous. So examples of this may be, no animals in the unit beyond, 20 pounds, or no pit bulls. Those would be examples of assistance animal discrimination that would be common. And then finally, fees. So setting fees for assistance animals. So saying, well, you can have your assistance animal in the unit, but you need to pay a $250 pet deposit, or you need to pay $200 a month to have your animal in the unit. That would also be assistance animal discrimination. Next slide. All right, so hopefully we have Will with us now. I'm going to turn it over to Will to provide some examples and kind of test your knowledge on what we've talked about so far in our presentation. So turning it over to you, Will.
Thanks, Cynthia. Before I start, just making sure, can everybody hear me? Yes, no? Yes.
You're a little bit
Quiet.
soft, Bill.
All right, I'll try to speak up. I'm glad that some people can hear me though, so I don't have to mime out the rest of the presentation. So sorry, I've been having some technical difficulties, but we finally made it. So my name is Will. I'm also an attorney with the Legal Aid Society of Hawaii. Going to be talking just about running through a couple scenarios. Now that we've covered the reasonable accommodation process, we're going to run you through a couple of scenarios to test your knowledge and kind of reinforce, what you've already learned today. As we go along, feel free to put your answer in the chat, or you can sit back and relax and save your energy for next week's presentation, where we will be going through a multitude of fair housing case studies. I see a couple people say it's a little bit quiet. I don't have a microphone or anything. It's just coming from the laptop, so I'll just try my best to speak as clearly as I can. All right, next slide, please. All right, so our first situation is Danielle. This is our first scenario. Here we have Danielle and some brief background information about her. Unfortunately, she lost her leg due to a recent accident. Her disability substantially limits her ability to walk longer distances. So accordingly, she makes an oral request to her AOAO to have her assigned parking space move closer to her unit due to her disability. So in this situation, every tenant/owner has an assigned parking space. Danielle is simply trying to obtain a different parking spot. Relatively straightforward fact pattern. Next slide, please. All right, so how do you guys think that the board should respond? Next slide. First, should the board require that Danielle submit her request in writing? Remember in the fact pattern that she made an oral request to the AOAO. And give you guys about 10 or 15 seconds. We won't sit for too long on these questions. All right, seeing a lot of no's in there. All right, good work paying attention to Nick there. So the answer is no. The board should not require that Danielle submit her request in writing, because a reasonable accommodation request can be made orally or in writing. Now, for the wrong answer, if you're a housing provider and you want to keep some sort of record regarding this request, I mean, you're free to feel so if you want to do that internally. You just can't require that the tenant make the request in writing. Alrighty, next slide. So, should the board request a verification of need from Danielle's medical provider? Yes, it is the board's right to verify the nexus between the disability and the requested accommodation. Or no, Danielle's disability makes it apparent how the request will accommodate her disability-related needs. I can see I made the questions too easy because answers are rolling in before I finish the questions, so good work there. Yep, you're all right. The answer is no. The board should not request a verification of need from Danielle's medical provider because Danielle's disability makes it apparent how the request will accommodate her disability-related needs. As we can see, not much additional explanation is really needed here. The disability is very apparent. You don't need a medical degree to tell that she has a disability and the request would accommodate her disability-related need. Can go to the next question. Okay, so unfortunately, all the parking spaces are currently assigned and occupied. Should the AOAO deny Danielle's request? Yes, since it is not possible to grant the request. Or no, the AOAO should talk to Danielle and attempt to find alternative solutions to accommodate her disability-related needs. All right, again, seeing a lot of no's. That's right, next slide. The answer again is no. The AOAO should talk to Danielle and attempt to find alternative solutions to accommodate her disability-related needs. If you recall from earlier in Nick's presentation, this is part of the interactive process. There might be alternative solutions out there, such as another owner willing to swap places or any other alternatives. Really just trying to see what's out there in terms of solutions before you just decide that you're at an impasse or just outright deny the request. All right, next slide. All right, last question for Danielle. The AOAO discovers that Danielle's lease is expiring soon and she's moving out next month. So should they still grant the request? No, because Danielle will be moving out shortly. It is no longer reasonable to go through the effort of granting the request. Or yes, reasonable accommodation request can be made and granted at any time. And mostly yeses. Good work there. Yep, and the answer is yes. Even though Danielle is moving out shortly, the AOAO should still grant the request because reasonable accommodation request can be made and granted at any time. So it doesn't matter if the tenant is in a fixed term, has a year left in their fixed term, maybe they have a month left like in this situation, maybe they're a month-to-month tenant or a week-to-week tenant. The reasonable accommodation request can be requested at any time as well as granted. All right, next slide. Alrighty, so that was it for Danielle. It was a good job. You guys were paying attention to Nick, or I made the questions too easy, maybe a little bit of combination of both. But that's okay if they're easy. I mean, I think a lot of reasonable accommodation requests are simple situations. I think it'd be very difficult to find a situation where it's a major head scratcher. I can see there are some questions flooding in. So there are some situations where, you know, you might truly be at an impasse, but for most reasonable accommodation requests, they are very straightforward. All right, let's take a look at Nathan and a little bit of background information for him. So Nathan has post-traumatic stress disorder, PTSD, resulting from a traumatic interaction with a dog. His unit is located right next to the apartment complex's park. Because of his unit's location, he often has to walk past other tenants' dogs, which worsens his disability-related symptoms. He makes a written request to the apartment complex to move into another unit further away from the park. All right, a little bit more information, but next slide. All right, so in this situation, how should the apartment complex respond to Nathan's request? Next slide. All right, first part. Should the housing provider require that Nathan use their own reasonable accommodation forms? If you recall from the fact pattern, he already did submit a written form. So yes, it is the apartment's policy to use their own standardized forms so they can obtain all the necessary information to make a determination. Or no, the apartment cannot require tenants to use a specific form for their request. Again, I'm already seeing answers rolling in, A+ for everybody. The answer is no. The housing provider cannot require that tenants use a specific form to submit the reasonable accommodation request. Again, to track back to Nick's presentation, there's a clarification on that. If a housing provider does happen to have their own form and the tenant is willing to use it, maybe it's just more convenient for them or they just approve of it, that can be okay as well. You just can't force or require that the tenant be using your forms that you created. You know, they can just do it themselves through any form that they would like. All right, next question. All right, so can the housing provider request a verification of need from Nathan? Yes, because Nathan's disability is not readily apparent, or no, because Nathan submitted a reasonable accommodation request, so he does not need to submit a verification of need. All right, seeing a lot of yeses. Good work there. That's correct. The answer is yes. A housing provider can request a verification of need from Nathan because his disability is not readily apparent. If you'll recall from the previous scenario with Danielle, she did not need to submit a verification of her need because the disability was apparent. She lost her leg. Here, Nathan has PTSD. It's not readily apparent, so a verification of need could be appropriate. All right, next slide. Okay, so if the housing provider thinks the verification of need is insufficient, can they contact Nathan's doctor to discuss further? Yes, if they believe in good faith that the verification of need does not adequately explain the nexus between the request and the disability. Or no, the housing provider should engage directly with Nathan as part of the interactive process. Okay, a lot of no's. I think I saw one or two yeses, but most of you got it. The answer is no. The housing provider thinks the verification of need is insufficient. They should engage directly with Nathan as part of the interactive process. I think this is pretty straightforward. I certainly wouldn't start cold calling tenants' doctors to try to get medical information from them. Work with the tenant, see what additional information you can obtain from them about, what the requests they're making and what other solutions might work. Again, this is just another extension of the interactive process. Alrighty, next slide. So, assume there is only one ground floor unit available. And remember, Nathan's request is to move away from the park. So after Nathan makes his request to relocate, another tenant is suffering from mobility issues. He submits a reasonable accommodation request to be relocated to the first floor. How should the housing provider proceed? The housing provider should find solutions that would accommodate both tenants' requests, or they should deny Nathan's request because although he submitted his first, the other tenant has a more serious disability. All right, I moved away from the yes/no answer format, but you guys adapted very quickly. Work. All right, the answer is yes, you guys are right. It's both. So the answer is the housing provider should find solutions that would accommodate both tenants' requests. I think like a major takeaway from this slide and the previous slide is in a lot of situations, you're probably going to find yourself that The reasonable accommodation request is very straightforward. It's easy to make the accommodation. I think it's rare that you might run into significant issues that would prevent you guys from proceeding further. But if you do, you guys should engage in the interactive process. And if you were here for week 3, Yaya had discussed that this is kind of a rare situation as well. It's not too common that one tenant's reasonable accommodation request might interfere with another tenant's reasonable accommodation request, but it does happen. And, just to be prepared to try to work with both tenants to see, what kind of solutions you guys can figure out together. Next slide, and that should wrap it up for our scenarios. Next week, week 4, we will have additional case studies. Hopefully they're a little bit harder for you, but you guys did great work today, and that's our presentation. We can move on to questions and answers. Thank you.
Thank you, Will. And this is the question and answer time. So welcome back, Nick and Cynthia. If this is a good time, we're going to jump into a bunch of questions that we have received from our engaged audience. And so those are great examples you provided, Will, with those scenarios. So thank you for that. The first question is a pretty straightforward question. It's asking, does the stuff today that we're learning about apply to condo ownership and HOAs?
Yes, the short answer to that question is yes. So the Fair Housing Act and state fair housing law is written pretty broadly, right? So it's going to provide to, landlords, AOAOs, property management companies, lenders in that context, a whole host of others. So yes, it would apply to AOAOs.
Okay. The next one here. Isn't handicap parking one, amount of stalls are based on number of units in a project, and 2, considered first come, first served basis as long as they have a placard? So I think they're kind of addressing the amount of available parking in this project and considering amount of tenants could request a reasonable accommodation for parking that's disabled. So this question again is asking, is parking on a first come first basis as long as they have a placard? Would that be sufficient?
So, go ahead, Cynthia.
No, go ahead. I was just thinking.
I know it's a little bit tricky question to unpack there. I can read it again if it helps.
I think I can take a stab at it, Brian.
Okay, sorry about that.
The property may have whatever designated parking for individuals with disability that they have, right? For guests or residents or what have you, but a tenant or a resident could still make a reasonable accommodation request to otherwise designate a spot that is not otherwise a handicap spot, right? So a spot that may otherwise be unassigned, for example, closer to their unit to be designated as such as a reasonable accommodation. So there's nothing that would prohibit a housing provider from designating other spots beyond what they may already have allotted for individuals that make reasonable accommodation requests and have a need for one closer to their unit, for example.
Okay. So thank you, Nick, on that question. I think we did our best with that one. Let's see what we got here. If we recall the heart stint tenant or the heart condition tenant, let's see. They ask, but let's see here. Let's go to a different question, and then I'll come back to the heart stint tenant. Actually, sorry about that. If a client comes to the window or approaches the property manager and is deaf, what communication devices are available besides pen and paper? And if a family member is translating, is that acceptable in any case or form of communication?
So I'll answer the second question first, the second question of that first. So a little bit of it's going to depend on the funding, right? So if there is federal funding or some types of state funding, a housing provider may be required to hire an interpreter or a translator to be able to assist the individual that is not, English as a second language, right? For housing providers that do not receive that funding, really it should be, and I know that it was discussed a little bit by the panel, and I think maybe even in the opening week as well, housing providers can work, should do their best basically to make that accommodation. In that case, it may be a family member, right? It may be a family member that is providing interpretation. It may be imperfect, but it's better than, asking someone who's English as a second language to try to communicate in English, right? So it's going to depend on the funding. As to the first question, again, it would sort of similar analysis would apply, right? So there may be some requirements in terms of whether or not the housing provider receives federal funding, but if they don't, then there may be services out there, but I think just making an effort to try to accommodate that person, if you are able to communicate in writing, if they're able to communicate in writing, that's obviously at least some way to help meet that need for them to communicate. So I think that would be appropriate.
Okay, thank you, Nick. Go for the next question that I have here. What questions can we ask of a support animal? Is it not a service animal? So what kind of questions can a property manager or landlord can pose to ask a tenant of a support animal is or is not a service animal?
I'll take that one. It's kind of a broad-ranging question, but I mean, generally, just going back to the presentation as well, if somebody is asking for an emotional support animal, it's likely related to some sort of mental impairment that might not be readily apparent, but the verification of need is largely speaking on their behalf and should contain all the information necessary that a housing provider would need. Outside of that, Cynthia had covered some of the other rules about, Hawaii administrative rules. So I'm not sure if you're, looking for questions in terms of vaccinations. It'd be a little bit hard without more information, whether it's related to, the tenant's disability, or if it's more about the dogs, such as, vaccination records, or if it's registered with the housing provider. If Nick and Cynthia, if you have any additional input on that.
Yeah, I would build on what Will said. I think everything Will said, I agree with 100%. I would just say, the information that the verification of need would require, and just to kind of reiterate from earlier in the presentation, it would have to establish that the person meets the definition of disability under the Fair Housing Act. It would have to articulate what the requested accommodation is. It would have to connect the dots, right? It would have to be demonstrating the nexus between that disability and the disability related request. Anything outside of those sort of touch points there would be inappropriate. So that's really all the housing provider is entitled to seek. So if the person does provide a verification of need, like Will said, it's likely going to have that information. If the person, maybe the person making the request doesn't know that information can be sought by the landlord, that's what the landlord should be asking for, right? So just those three points essentially.
Hey, thank you so much, Will and Nick, tag teaming that question there. Let's go on to the next one. I think we have a lot of generous time to go over several more questions. Talking about animals and pets, so yeah, assistance animals, we have another question. Can the landlord tell potential tenant they must have pet insurance for their emotional support animal or assistance animal?
So I'm unfortunately not familiar with pet insurance, but if the question is aimed at renters insurance, if the landlord requires rental insurance in like the lease, that's something that they require of all their tenants, then yeah, that's fine. But if it's going into something beyond just those reasonable restrictions, like putting different conditions on a person because they've requested an accommodation for an assistance animal to be in their unit, then that would, potentially creep into discrimination.
Alrighty, and the next question we have here, can the number of assistance animals be limited? So, can it be like 2, 3,
I get this question every year. um, well, a person can have multiple assistance animals. A person can have multiple service animals. They can have a service dog and an emotional support animal, just like a person can have multiple disabilities, right? So a person can have a need for example, for a heart condition, and they need a service dog to alert them whenever their heart rate is increasing, for example. They may also have depression, and they may have a need for an emotional support animal. So there's not a hard and fast line on how many animals a person can have, but a person can have multiple depending on their disability related needs, if they have multiple different disability related needs, right?
So,
Okay.
sorry, just
Go
going to
ahead.
jump in real quick. So the analysis for the housing provider is the same for each individual request, right? So if it's a service animal, again, if the disability related need is readily apparent, then that's the end of the analysis. For requests where the disability is not readily apparent, then they can seek that verification, right? So they would be entitled to seek verification for, the second, the third animal, whatever it may be. And if there is a way to articulate the nexus between the disability and the disability related need, then it would be appropriate for that person to have potentially multiple animals.
Let's see. So potentially it could have one or two or multiple service animals or assistance animals. So that's like a driving point there in many presentations that's out there. Let's see here. Oh, so going back to one of the questions I was trying to tackle on is what can a housing provider do if the requested accommodation is not available other than just documenting the request?
Take it if you wanted to, Nick. So Nick kind of touched on this in his portion of the presentation, which I know was quite longer because I'm a pretty fast talker. But something that they can do is engage with the individual directly to see if there's another way that they can accommodate their needs in the meantime, which is why, the interactive process is so important. They can, have a discussion with that person and see if there's some other thing that they can provide either in the meantime while they're waiting for that ground floor unit to become available. I think this was going back to the heart stint question, or they can, figure out if there's some other way that they can accommodate their request other than just documenting it and moving on.
Okay, thank you, Cynthia, for tackling that one. Sometimes it's a difficult question, so we need to kind of go back to that, and I appreciate your help in unpacking that question for me too. I do have another one here. If the apartment complex has a no pet policy and a tenant brings a guest that has a assistance animal, do we have to allow the guest with the assistance animal, or can we tell them it's not allowed because they are not the tenant to this building?
I guess I can, Cynthia, go ahead.
I was going to let you tackle it. Well, my answer would be yes, right? So the Fair Housing Act applies to individuals in all parts of the real property transaction. So in my opinion, if the individual has a need for an assistance animal, and they may be just a guest to the building, I would say that the housing provider should work to accommodate that individual with the disability, even if they're just a guest. Nick, I don't know if you want to add anything.
No, I mean, I think the same analysis would apply in terms of, what verification and whatnot might be required, right? So, the housing provider may be entitled to seek that verification if the need is not readily apparent, which I now sound like a broken record. I feel like I've uttered that line about a dozen times here. So, yeah, that's all I have to add on that.
Great question and great response. Thank you. Let's go here to another question. Are tenants with assistance animals required to have them at all times? For example, can't leave them home alone.
Short answer to that is no. There's not a requirement that an emotional support animal or assistance animal would be required to be with the person at all times. So, and this, I guess, sort of speaks to the larger issue that I think a lot of these questions get at is, right, this sort of the reasonable restrictions thing, right? You know, if the animal, while they're unattended, is causing other issues, right? If there's noise issues and other, there's other issues that it's causing, the landlord is still always entitled to enforce their rules and policies as they normally would. But just the mere presence of the animal being, in the unit for a few hours here and there while the owner is out, grocery shopping or working or whatever, there's nothing wrong with that.
Okay. Let's see. I got here another question. What should a housing provider do when the multiple animals or assistance animals create major damage to a unit?
So if the question is, what options does the housing provider have if the assistance animal, for example, damages the unit? When the individual moves out, generally they would have remedies under the landlord tenant code. And if it's a matter of, if there's some sort of direct threat or, the animal is biting people on the property, obviously that the housing provider can create restrictions on that. But if it's just like damage to the property, what options do they have after the person moves out? That's something that is handled under the residential landlord tenant code.
All right, next question. We're breezing through on so much questions here, so I'm glad we have this time here to have this interactive discussion. So I want to whip through another couple more. Do you have any information or recommendations, guidelines for tenants having an assistance animal in a shared unit? So maybe they have like a 1-bedroom or 2-bedroom and they're sharing a living space. Do you have any feedback about that kind of situation?
No feedback, I guess, other than, at least to the extent that I understand the question, other than, the housing provider should be handling that request as they normally would, right? I mean, if the individual needs an accommodation for their disability, they are able to make that request and the housing provider should consider that accordingly. The other roommate or other unit, other bedroom in the unit or however the setup is, that person would not have any bearing on whether or not that accommodation request should be granted, right? If they don't like dogs or if they don't, whatever the case may be, it wouldn't have any bearing on the analysis that the housing provider would need to undergo to determine whether or not the request was appropriate.
Okay. For a reasonable accommodation transfer from a 1-bedroom unit to a 2-bedroom unit, what if there's no units available? Can they be placed on hold or some type of wait list until there is one that can be available or open up for them?
I could take that one. Again, this kind of goes back to the interactive process. There might not be an immediate solution. You should try to work with them. One of those options could be, especially if the tenant is okay with it, if you're waiting for somebody's lease to end so that you can move them to a first floor unit. Maybe it's a larger property and they own other buildings. If the tenant's okay with that, there's something that they could work out with there. There's no one specific right answer in these scenarios. It's more about working with an interactive process to see what you guys can work out to accommodate their disability.
And just to add to that, I completely agree. But yes, if the person wants, say a 2-bedroom unit, or going back to the heart stent example from earlier, if they want a ground floor unit or whatever, and one's not available, like obviously the housing provider can't grant an accommodation that's not physically possible, right? That unit doesn't exist at that point in time for whatever reason. It is what it is, right? But again, it may be, as Will said, one of the solutions may be, as soon as one becomes available, we'll offer it to you, right? And that might be 2 months, 3 months, 6 months, it really depends obviously on the property and all those types of things, but it just needs to be, as Will was mentioning, sort of that continued dialogue between housing provider and the person making the request.
Okay, thank you, Will and Nick, for that response. Another question here is, what can landlords do if assistance animals are damaging common areas, such as peeing in the hallways, for example? What can be done if assistance animals are damaging common areas?
Take this one. So going back to reasonable restrictions, right? So a housing provider can put reasonable restrictions on the individual, for assuming responsibility for making sure that there's no damage in common areas, right? Making sure that the person is cleaning the animal's waste if they're peeing in common areas, right? So that's permissible under the applicable law would be the Hawaii Code. I think it's section 1246-306. It's in the PowerPoint presentation if you want to look back on it.
Okay. Awesome. Thanks, Cynthia. Let's see. Tenant is asking to relocate to a neighboring property with a bigger yard for their emotional support animal. Is this considered a reasonable accommodation? I'm assuming both properties are owned by the same or managed by the same entity. So if a tenant's asking to relocate to a neighboring property to have a bigger yard for their assistance animal, would this be considered as a reasonable accommodation?
So I can take a stab at this one. So the accommodation is for the individual with the disability, right? So we're working to accommodate the individual's disability related needs. So maybe there are circumstances that I'm not familiar with, but it seems as though that would be just something that may be better for the animal, but we're not making an accommodation for the animal, right? We're making an accommodation for the person. So I don't want to just say no, but it's hard to imagine the circumstance under which that would be a reasonable accommodation request that a housing provider would have to consider.
Okay. I think this question has a good discussion point, perhaps, but let's just try it anyway. Thinking about mental health issues, is there changing trends or an increase in accommodation requests since the pandemic?
It's a good question. I mean, I think folks have been under a lot of pressure in addition to sort of the regular pressures of life, right? Based on a lot of different, facets of the pandemic and the impact, right? So, I mean, I think just kind of going into what Cynthia started the presentation with in terms of the data, like disability has always been sort of the predominant, protected class that we see complaints based on. That's true for HCRC. That's true for HUD. I don't know that there's been some like dramatic increase or like large volume increase in that, but I do think, it's easy to like kind of comprehend how those issues may manifest given kind of the circumstances of the last few years. I think it's also worth considering, how we think about mental health, right? I think people are more knowledgeable about mental health. I think people are more aware of seeking services and support. So some of the issues that may have previously been undiagnosed or maybe untreated are now coming to the forefront for people, and they're able to actually understand a diagnosis and be able to make reasonable accommodation requests on that basis. So I think it's certainly an evolving area and something to continually to be mindful of.
Wow, well said, Nick. Wow. Okay. I think we have time for a bunch more questions. Yeah, okay. All right. Thank you, Cynthia. Let's see here. If two tenants apply for the same rental and both meet the minimum financial qualifications, but one has an assistance animal, but the other doesn't, does the applicant with the animal have more rights to this rental unit than the other, or can I choose either?
That is certainly a question.
I'm not sure I heard the whole, I'm not sure I understood. Can you repeat it, Brian?
Sure.
I apologize.
If two tenants apply for the same rental and both meet minimum financial qualifications, meaning they both can afford the unit, but one has an assistance animal and the other does not, does the applicant with the assistance animal have more rights to the rental than one without? Or can I choose either? So looks like this property manager found two tenants and they both can afford the unit. And the only thing that separates this tenant from each other is having an assistance animal. Does the applicant with the animal have more rights to the one who doesn't have an assistance animal?
Go ahead, Cynthia.
No, go ahead.
I'll give a bit of a lawyerly answer. Having an assistance animal doesn't, enhance your housing rights or give you, preference over someone without one. But I would also caution against using what it sounds a little bit, and I don't know that this is the intent of the question, so don't, that's not what I'm trying to say, but it also shouldn't be used as a factor to make the choice of the other person over the person with the assistance animal, right? They should be treated the same, right? So, and this sort of harkens back to what Cynthia was talking about earlier in terms of assistance animals not being pets, right? So to the extent that a housing provider is not wanting a dog or not wanting a cat or whatever, if they're using that as a basis to choose this one prospective tenant over another, that may be, an act of housing discrimination to deny the person on that basis. So it shouldn't really be used in that way, but it's also not, it's not giving preference. I like what someone said in the chat here about a wait list, and I think that's a fine way to do it too. If you're working off of a wait list and it just happens that one applied earlier, they're otherwise equally qualified, that's a great way to break that tie, right? Whether that person that's higher on the list is the person with the emotional support animal or not, right? So there's other ways, I think, to think about how you can sort of break the tie, so to speak.
If I can just kind of build off that, I think, part of our beginning portion of the presentation, the purpose of requests for accommodations, including for assistance animals, is to give everyone the equal right and opportunity to use and enjoy their housing. So a person isn't making a request for having an assistance animal in the unit to give them more rights to the property than other people, right? They're making that request so they can have the same opportunity to use and enjoy their dwelling as other people without disabilities.
Hey, so I think we answered that question. Thankfully, that landlord will make a good decision there on that situation. Let's see, who would a person contact directly if any of reasonable accommodation or requests like that are overlooked or denied? Who can someone contact?
You're talking to us. Yeah, so I think there's a few different folks you can reach out to, right? So if you're a tenant that's made a request that's been overlooked or denied, and you want assistance in trying to reiterate that request or to file a complaint either with the Hawaii Civil Rights Commission or with HUD, you can contact us. Our intake information is available in the presentation, I believe, but we can put it in the chat as well. And then also our fellow colleagues that have been part of these presentations as well, the Department of Housing and Urban Development can also assist, as can the Hawaii Civil Rights Commission. You can file complaints with both of those organizations. And just to take it on the other side of things, to kind of extrapolate the question a bit, if you're a housing provider and you're unsure of what to do, those same resources are available to you, right? So as I mentioned, we can provide technical assistance, so can HUD, right? So if you're unsure how to handle a request for whatever reason, always better to seek that information on the front end rather than, face potentially negative consequences on a point later down the road.
Thank you. Well, so to answer this question, you're sitting and watching the people you can talk to. Very good. Nick, Bill, and Cynthia are available for you. Very good. You need to bring up the slide. Oh, there. Yeah, that's definitely a good slide. If you need the contact information there, looks like that 808 number 536-4302, or you can email them too. Looks like fairhousing at legalaidhawaii spelled out .org. Do we have time for a couple more questions? I think so. Yes. Okay.
If
All
you
right.
want, I can just explain others. So the email is there, so that if people have questions, so say a landlord has a question about a certain situation, we do provide technical assistance. Although we can't give the housing provider advice about what they should do, we do provide technical assistance when needed if a housing provider has trouble and needs to figure out how to navigate the Fair Housing Act.
Okay, it looks like we have about 5 more minutes of question and answer time, I think. Yeah, we can do it. This question was submitted before the session started or as a previous question. If a property allows only assistance animals, are they required to have a designated area for the animals to relieve themselves, like a assisted animal bathroom or area?
So in the event that a building is, say, has a no pet policy, but obviously they're allowing, assistance animals because that's the law, they don't have an obligation to have a designated area for those animals. They can certainly do so, right? I mean, it may make sense for them to do so for a variety of reasons, but there's not a requirement that be something that they create as part of accommodating that disability-related request.
Okay, next question we have here. Is an AOAO in violation of the Fair Housing Act if there is a delay in the decision of a reasonable accommodation or modification request?
Short answer is they may be. They may be. If it's an unreasonable delay, and there's not really any reason for it, yeah, they may be in violation of the Fair Housing Act.
Yeah, an unreasonable delay can have the same effect as a denial, right? So if an individual makes a request and it goes unacted on for weeks and weeks and months, that's the same thing as a denial, and that's where it can be discriminatory. Certainly if the housing provider or AOAO is seeking additional information that they are entitled to during the interactive process, and they're waiting for that information, or that type of thing, that's maybe a little bit different analysis. But just a delay in and of itself can be problematic. And what I would mention, I guess, to the point I just said, housing providers can also seek to reduce barriers by granting requests in the interim, even if they do require additional verification, right? So if there's a request that's going to maybe take some time to verify, but it's not going to cost the housing provider any money, and it's just, you have a reasonable accommodation request for an emotional support animal. We want a verification of need, but while it's pending, you can have your emotional support animal. We'll allow it, and then we'll see how the interactive process plays out with that. So nothing's preventing a housing provider from granting a request on the interim while they seek that additional verification.
Okay. let's see, this question asks, here, let's see, what should an individual with a disability ask for an accommodation or modification? Should a disabled individual disclose their assistance animal prior to renting?
So I can take this one if you'd like. So the if the question is whether the person should request an accommodation or modification before moving in, the Fair Housing Act doesn't require a person to make a request at any particular time. So they can make it before, after they move in, at the time of application. And there's no sort of mandate that a person be made to disclose, an assistance animal prior to them moving in. So the important thing to note is the person can make that request at any time, whenever they feel like they need it. And a lot of times, a person might not outright disclose an assistance animal prior to moving in because they know that a landlord will discriminate against them on that basis. So sometimes landlords feel like, oh, well, they deceived me because they made this request after they've already moved in and signed the lease and everything. But, really the request can be made at any time in that process, right?
And to highlight what Cynthia said, it's a really important point for housing providers to be mindful of, because the type of discrimination that she references can happen on both ends of that, right? So the tenant does disclose it, and then they're denied a unit, obviously discrimination. They don't disclose it, they get the unit, and then they make the request, and then there's subsequent retaliation or issues from the landlord at that point. And I think, again, to reiterate what Cynthia said, it can be made at any time. So it's really up to the tenant to make that request at a time that they feel appropriate and would make sense for them in terms of, securing housing and meeting their disability related needs.
Okay, thank you. Awesome. The next question is a pretty recent question. If a tenant has registered or requested, got approved their assistance animals years ago and can no longer provide any documentation for their animal as they no longer have that disability, does that animal become a pet?
So it's hard for me to imagine, and maybe there are circumstances, but it's hard to imagine a situation in which that would be the case. I mean, if someone has a disability related need and makes the request, I don't know how whatever their disability is, right? So whatever it is that's substantially limiting one or more major life activity is suddenly going to go away, right? So I don't really know when this would come into play, and the housing provider should tread pretty lightly in terms of seeking to re-verify previously a granted accommodation request. So I know that's not a super on point answer, but it's unlikely, I guess.
Yeah, sounds very specific question there. Let's see, another question that sounds kind of specific and would really help get your help on this. Some websites sell certificates, registrations, and licensing documents for assistance animals to anyone who answers certain questions or participates in a short interview for a fee. Can these documents be considered as verifications of need?
Oh gosh, well, we see this one a lot, unfortunately. Some people think that, going on a website and paying a fee is going to help them with getting a verification of need. And unfortunately, the thing that comes into play is that person is generally not a knowledgeable provider, a person who's knowledgeable about this individual's disability, who can verify that disability related needs. So unfortunately, people fall into the trap of, thinking that they need to pay some website, and they go and do that and think that they've done everything that they need. But no, generally those websites wouldn't be sufficient for providing a verification of need for that individual. If it is something where the person's provider is maybe remote, so they're doing telehealth and they used to live in like the state of Wisconsin or something, and they're still seeing that provider, then that obviously would generally be sufficient, because that individual they're seeing, they're knowledgeable about this person's disability and their related needs. But usually the websites that have the certificates that, you know, say this person is needs a emotional support animal or something, those are generally not provided by a knowledgeable provider.
Thanks, Cynthia. Wow, good information. Next question here. Can I deny a wheel-bound, I'm sorry, I said too fast, didn't I? Can I deny a wheelchair-bound tenant because the unit I'm renting has stairs in it?
No. They may need a modification, right? They may need to be able to remove the stairs or build a ramp over the stairs, or however the property is configured to be able to enter the unit. But denying them on that basis would be violation of the Fair Housing Act. And then again, it goes back to who pays for the modification. So, you know, if it's a private landlord-tenant relationship, there's no subsidy, anything like that. You know, the person making the request could be made to actually pay for that physical modification. But denying them simply because they would like to move into a unit that currently has stairs would be discrimination.
Okay, thank you. I think we have about a couple minutes left of this show today, or this episode, this season. I don't know how to say it. Let's see if we have one more question, and then we can wrap this up and then put some closing remarks to this today's presentation. And let me find it here. So if they are seeing a provider, oh, sorry. I'm trying to find a question. If a project is allowed, say 4 handicap stalls, and due to accommodation requests, you assign those stalls to 4 tenants, is the project still in compliance with ADA?
So I'll answer this question with a non-answer. So Americans with Disabilities Act, separate and apart from the Fair Housing Act. So whatever it is that we're doing to meet individuals' disability-related needs and granting reasonable accommodations or modifications may or may not have any bearing on whether or not the property is in compliance with the ADA. So I don't think we really want to go there. What I will say, though, is it's just important to remember that, you know, just because someone makes a request for, say, a parking spot due to a disability, you don't have to assign them a spot that's already, you know, for folks with disabilities, right? You can assign them a otherwise unassigned spot elsewhere on the property if it meets their needs, right? So we can be a little bit creative and thoughtful as to how that should be handled. So with that, I think we can wrap things up. Thank you, Brian, for all of your hard work and asking us questions here.
Thank you
So
all. Thank you.
We'll be back next week for our last session, and we're going to have the opportunity to do sort of a deep dive into some different case studies, sort of a culmination of the last 3 weeks of material, and give you folks a chance to test your knowledge and ask a few final questions of us. So thank you all. See you next week.